Denise Brown, and I preside over Family Court Division 7 in Jefferson County. Welcome to our videos on the dependency, neglect, and abuse case process, sometimes referred to as the DNA docket. These videos are designed to provide you with information and to explain each step of the DNA process so that you can better understand how to become reunited with your children.
Hello everyone, my name is Judge Angela Johnson. I'm from Family Court Division 1.
My name is Hugh Smith-Haney. I am the judge in Family Court Division 2.
I am Deborah DeWeese, and I am the Family Court Judge in Division 3 in Jefferson County.
Hello, I'm Judge Dolly Berry, and I preside in Family Court Division 4 in Jefferson County, Kentucky.
Hello, I'm Tara Haggerty, and I am Judge in Family Court Division 5.
Hello, I'm Judge Christine Ward, Family Court Division 6.
Hi, I'm Judge Gina K. Calvert. I'm the Family Court Judge who presides in Division 9.
Hello, I'm Paula Sherlock. I'm the Chief Judge of Jefferson Family Court and the presiding judge in Jefferson Family Court 10.
Now let's talk a moment about the courthouse and more importantly the courtroom. I'm sure you would like to know what to expect today. When you entered the courthouse today, I'm sure you walked through the metal detector, which was staffed by our deputy sheriffs in their official uniforms. The sheriff is here to help you provide for your safety and the safety of others. The sheriff provides security in the courthouse and assists the judge in maintaining order in the courtroom. Always obey the sheriff's directives, and he may give you some limited instructions during your hearing. Remove your hat before you go into the courtroom, and remember not to stand with your hands in your pockets. Always dress appropriately when you come to court. Be respectful and courteous to all. Please remember to turn off all your cell phones and all electronic equipment.
Every case has a social worker assigned to the family that will help the family get the services and treatment that are needed to enable the child to either remain in the home or be returned home safely. It's very important that you stay in contact with your social worker between court dates. The social worker will appear at the court date to update the court regarding the family's progress in treatment. Every parent involved in these proceedings is entitled to have an attorney represent them. There's also an attorney appointed for the child in every case. It's called the guardian ad litem, or GAL. That attorney is a specially trained attorney to represent the best interest of the child. That attorney is independent from the court and the other attorneys involved in these cases.
Each court has a clerk. The clerk will sit with the judge in the courtroom, will assist in any documentation issues, documenting any events, provide orders, copies of orders, and other paperwork for the various parties. The judge's job is to hear the factual information provided and to make the appropriate decisions relative to the parents and their children. The judge will explain to the parents what the purpose of the hearing is, and this is very important on the dependency, neglect, and abuse docket. At the close of any case, as always, the judge will review the facts and make a decision based on the testimony and any other exhibits. The judge may also, if necessary, issue orders that the parties will have to follow. And at some point at the end of the process, the judge will make final decisions concerning the parents and their children.
The Family Court Support Worker is the contact person for the parties and anyone else who has an interest in the case. He or she may help set up court services and inform the court on people's compliance with court orders. The Cabinet for Health and Family Services provides a social worker who works with the family and presents information to the court regarding allegations of dependency, abuse, and neglect. This person also provides the court with information regarding compliance with case plans, reunification, and permanency for the child involved. A court-appointed special advocate, otherwise known as a CASA worker, may be appointed by the court. The CASA worker is a trained local volunteer who works with the child and the family and gets to know everyone involved in a case, including teachers, doctors, neighbors, siblings, whoever is important in the child's life. The CASA volunteer's role is to make an independent investigation and give his or her recommendations to the court on what is in the child's best interest.
A prosecutor from the county attorney's office will be present for the hearing. It is their job to represent the Commonwealth and to present the case to the judge. It is important to know that the court, the judge, and no one from the cabinet can present you with legal advice. When you need legal advice, you need to speak with your attorney. Make sure that you're present for all scheduled hearings. If for some reason you can't be there, make sure to contact your attorney.
Want to remind folks of a couple things. First of all, these are not criminal cases. Child Protective Services has become concerned enough to bring these cases to court. There are usually 4 court dates to a dependency, neglect, and abuse case. There's a first court date is a temporary removal hearing, usually followed by a pretrial conference. Usually a trial date, and then finally a disposition date. And also, this is very, very important. Not only are these civil cases, it's important to remember these are not custody cases. Child abuse cases are special. They are temporary cases. The goal of these proceedings is to return the child to the home of removal just as soon as it's possible. Okay?
The first thing you should know is you are entitled to an attorney as a parent. Second, you're entitled to a full hearing where you are to be heard, where you can present witnesses and evidence on your behalf, where you can cross-examine witnesses that are presented against you. You're also entitled to receive what we call discovery, which is evidence that they will be using or could use against you. If you can't get those witnesses to court, and if you feel like they are crucial to your case, you can always ask for a subpoena, and the court would help you with that, or the clerk's office would subpoena those witnesses, and then they would be ordered to appear on your behalf. You have the right to appeal. Let's just say you have that hearing and the court rules against you. You have a right to appeal the court's decision. However, if you enter what we call a stipulation, you waive your right to appeal.
After the petition has been filed and an emergency custody order has been issued, the next step in the proceedings is for the court to have a temporary removal hearing. A temporary removal hearing, or a TRH as it is sometimes called, allows the court to consider whether the child's current placement is a safe environment. The court has several options. The first option is always to see whether the child can be placed back in the home with their parents with a safety plan in place and other resources to support them while the case is moving through the court proceedings. The second option is to consider other relatives, or what the court sometimes refers to as fictive kin. Those are people that love you and will take good care of you, but may not necessarily be a blood relative. Shortly after the pretrial, the court will hold what's called an adjudication, or you may know it as a trial. That means that the court is going to hear evidence on the allegations that are in the petition. All parties are allowed to present evidence on those matters, and at the conclusion of the evidence, then the court will enter findings of fact and conclusions of law as to whether the child can be declared dependent, neglected, or abused. The disposition occurs after the trial, and it gives the court an opportunity to get more updated information on the progress that has been made by all parties. During the disposition, the court will consider the current status of all parties. The court will review how the children are doing in their current placement, how the parents are doing in working on their reunification plan, and whether there are any other services that need to be put in place. During the proceedings, motions can be made at any time. Some of the motions that are normally heard are motions for return or a motion to expand parenting time. The goal in dependency, neglect, and abuse proceedings is reunification of the family. Not all DNA cases end with a reunification of the parent and child. In some cases where the parents are not working the reunification plan that has been developed by the cabinet, then the cabinet may make a motion for permanent custody to be granted to the temporary custodian. This means that the custodial rights of the parents will be affected in a negative way, and the court is obliged to set up a hearing, take testimony, and will enter written findings of facts and conclusions of law in this regard.
Thank you for watching this video that we have created to guide you through the dependency docket process. Our goal with this video was to provide you with information and support The overall goal of the dependency docket is to keep families together or reunite families when safety issues have required us to remove children temporarily. And we try to offer services to further that goal. If you have any questions as you go through this process, feel free to ask your court-appointed attorney, the child's guardian ad litem, the social worker who's working with you, or the judge that you're in front of. All of us are here to assist with keeping families together or reuniting families. So let us know what we can do to support you in that goal. Thanks again for watching our video, and I hope that you found it helpful.